Hi, this is Neil Janeja at Octopus Law talking about trademarks today. Trademarks are one of my favorite areas of law. I've filed well over 1,000 trademarks in the U.S., in U.S. states, in other countries. I love this area of law. Trademarks are one of the types of intellectual property, along with patent law for inventions, copyrights for art, and trade secrets for secrets. So trademark law protects marks in trade. So these are brands protected in interstate commerce. Trademarks cover brands and such things as words, slogans, logos, and in some cases even colors like Pink Panther insulation, aromas, audio like the Intel noise or the MGM Lion. So it can be pretty broad. Sometimes they'll even cover interior, exteriors of restaurants or buildings. And this is something that can last for the life of the business. So it requires a couple of things. You should be using it in interstate commerce. That's a requirement. It shouldn't just be in one location in a city, and it should be in use in the U.S. to be protected. The body that covers this is called the United States Patent and Trademark Office, and they're the ones that are going to review applications. In order to get an application to register as a trademark, it will take at least 8 months, sometimes a year and a half. You do what's called a clearance search. This is looking at other types of brands, other types of marks, as we call them, and seeing if you infringe on them or conflict with them. And this doesn't mean the same word or same name. It means anything likely to cause consumer confusion. That's the legal test. Now, what does likelihood to cause consumer confusion mean? That's very fact-based, and it depends upon what the mark or brand is. So for instance, if you're doing something like boats, slick craft and sleek craft might be likely to confuse on something else, but a boat owner is rather sophisticated. They usually know what they're buying. In that case, it was not found to be likely to cause consumer confusion. Now, on the other hand, if you're walking down a grocery store aisle and you see a red can with white cursive writing, you might impulse purchase that thinking it's Coca-Cola. And that would be an actual piece of evidence of consumer confusion and would likely infringe on the Coca-Cola branding and the Coca-Cola trademarks. So what you have to do is be able to understand use in commerce and the trademark search system called TESS and determine whether you're likely to cause consumer confusion for the types of goods you're in, how similar your mark is to those existing marks used in trade. That is the main issue that would reject a trademark. So likelihood of consumer confusion is a 2D rejection. So when you apply for your trademark and you fill out the application, you want to draft it in such a way to address those potential similar marks in order to get your trademark through, as well as be able to protect your brand effectively and not receive the dreaded cease and desist letter. So the trademark examiner accepts your application, takes about 3 to 6 months to pick up the application, and he'll review it for likelihood of consumer confusion as well as a number of other potential issues, as well as looking on if you are using commerce or if you filed under what's called a 2B application, an intent to use application, which says, I want to protect this mark now, and I will use it in commerce at a period of time not to exceed 3 years from when you tell me I can use it. But there's fees throughout the process. If the examiner decides that your trademark can move forward, or if he issues an office action and you can overcome that rejection to proceed forward, then the application goes to official publishing in what's called the Official Gazette. This is a body of trademarks that are applied for that are then opened up to third parties to oppose that registration. And they can raise an opposition. What usually occurs is they will reach out and try to negotiate a settlement. Or maybe if you limit it or change certain things, maybe it's in all these colors. If you just narrow it to one color, we'll let it through. If no opposition is received, then you move forward to registration and you have a nice certificate now emailed to you since they no longer mail them, and you can use your trademark. That means you can use the Circle R logo. Prior to that, you can use the TM at effectively any time. The TM says, I'm using this brand and I believe it's a trademark, and now you're on notice. Now, if you receive an opposition and you can't settle it, it goes into a type of litigation. Much of this can be done online, and you're effectively trying to get your trademark through while they're trying to kill your application through a form of litigation. And that is your brief trademark talk for today.